Hello, thanks for staying with us on BERNAMA today and on BNC, where it's all about you. You're still with me, Lane Abla, and in the studio I'm speaking to a very special guest today. I'm speaking to Geeta Kandya. She's, of course, our Director of Intellectual Property and Trademarks. And we're speaking about a very interesting topic today. We're talking about elections. GE14 is just around the corner, so everybody is gearing up towards elections. And elections have a reputation of being fast-moving and overall quite cutthroat. So we want to explore a little bit about whether or not there's IPs that's been sort of infringed in the process. And here today, Geeta, how are you doing?
I'm good, thank you.
Good to have you in the studio. It's a very interesting topic. Everyone's talking about GE14. It's heating up. Nomination days just around the corner, and polling day will be on May 9th. And you can tell that campaigning is just on the fringes of everywhere. And we're wondering how this affects intellectual property as a whole.
Okay, so I guess first things first, we have to say this is not fake news.
Okay, yes.
No, there's a factory that's found. Yeah, so this is not fake news, but intellectual property comes in a lot of scenarios, including elections, especially when it's all about promotion and marketing. Each candidate wants to get their name out there, wants to get their party name out there.
Yeah.
Flags are out.
Yeah.
So it's whether are they using correct images, are they using their own images in their buntings, posters, or are they taking it from internet? Is there a copy and paste method?
Right. Is there permissions in that process, whether or not they have actually established whether they can do so? Before we go into the Malaysian scene, because there are a few questions that I have, because I think there are quite a few things that are out there already. Let's talk about in the US, because election is a big thing in the US, and I'm sure there's a lot of IP rights that have been sort of like I don't know, encroached in the process.
So I mean, we spoke about intellectual property a few times on BERNAMA and about who owns rights. So the rule of thumb is the person who takes the photos or creates that product or image owns the rights.
Right.
So there was a very famous case, actually. It's during the Obama Hope campaign in the US. Yeah. And in that campaign, it was in 2008, there was a really famous street artist called Shepard Fairey, and he created a poster, and that poster went really popular in the campaign. Everyone started to use it for buttons, for shirts, for posters, for postcards.
What we can see on the visual right now, of course, on the right is a picture of Obama, which is just a file picture, but on the left is sort of like the rendition or the creation.
The creative derivative of the actual image.
Right.
But so the poster, the one that you see with lots of colors on it, is the one the street artist worked on.
Right.
And he made $400,000 US from sales, from licensing. And 1.5 years later, Associated Press, which is a news agency in the US, found out that that image, that poster, was a rendition or work done on top of a photograph taken by a freelance photographer.
Right.
Which means they own the rights.
Oh.
So there was a dispute, a 2-year dispute in the US courts.
Okay.
And the dispute was really interesting because they were going to sue the street artist, the Shepard Fairey, and before they could sue, he sued them for a declaratory judgment, to ask court for a judgment saying that I own the rights to this poster, I created this poster, I did not copy them, there was no infringement. In that case, it was twisted because Fairey, even though he used the defense of fair use, so the defense of fair use is I can use images if I'm using it for news purposes or private purposes.
Right.
So there's some defenses that are allowed in corporate infringement.
Right.
So he might have had a good defense, but in the case itself, he actually did some criminal act. He hid some evidence and destroyed some evidence, and that wasn't very credible. So the case actually was very imbalanced at that point.
Right.
And in the end, there was no decision because both parties settled out of court.
I see, okay. But in that case, because I'm looking at the source picture, the source picture is a photograph that was taken by a freelance photographer. Then the street artist, which created the poster out of the picture, what happens to the owner of the face, Obama himself?
That's a very good question.
Yeah. Does he get anything out of this?
Well, there's image rights, but this was for his campaign.
Okay.
So it's for him, it's good as publicity. You know, they say good publicity or bad publicity is still publicity.
Right.
There's image rights. So celebrities, politicians have image rights. If he could have exercised it, but they were not using it.
Yeah.
for a different purpose.
detrimental purpose.
It was for the purpose of promoting his own campaign.
Right.
So he could have exercised it, but it was not necessary here.
So he could have exercised it. So as
If
the
it was
owner,
for a different purpose, yes. And there's been many cases on that. Rihanna's image was used by
Yes.
Topshop on,
Yes.
on shirts, and there was no consent given.
Correct.
So, but what was interesting about this Obama case was that in the end, both parties settled out of court, and the financial settlement, the terms were confidential. But the business arrangement was really interesting, and that's the best thing about disputes. In the end, if someone's misusing your rights, they can become a business partner. So the street artists and Associated Press got a business arrangement whereby they say that, okay, moving forward, all income or revenue earned from the image being used, this specific image for the Hope campaign, will be shared equally.
Right, okay. We'll take a short breather right now.
Sure.
When we come back, we'll talk about the next person, which is Trump, which of course is even more interesting than Obama. Stay tuned, we'll be right back.